A warm welcome to lesson number 38 in our 50-part series on the law of evidence. In today's lesson, we will be looking at section 60 of the Act. We have already seen section 59, and section 59 told us as to what oral evidence can be given for and about what it cannot be given for. However, in section 60, we see as to how oral evidence should be given. So in our previous lesson, we'd seen that section 59 tells us that oral evidence can be given for all facts except the contents of a document. Now, section 60 tells us that oral evidence must be direct. I'd advise you at this point to either pause the video and look at section 60 or perhaps look at a copy of the Bare Act by your own self. Look at the whole of section 60 before proceeding any further with this lesson. Now, section 60 is interesting. We begin with the short title, of course. The title tells us that oral evidence must be direct. Okay, point taken. Let's go further and we look at the first line that we see in the body of section 60. It says that oral evidence must, in all cases whatever, be direct. That is to say, and then it goes on to tell you what direct is. But before I go there, I want to ask you something. What is the purpose of this emphasis here? In all cases, whatever. Like, instead of writing in all cases, whatever, if it had simply been oral evidence must be direct, which is to say, let's say if I strike this off like this. If I were to simply say that oral evidence must be direct, what is the difference between saying that and adding the emphasis by saying in all cases, whatever? Please let me know in the comments section. The truth be told, I do not know as to why this emphasis has been added here. So in case you're able to think of something or you're able to find the answer, I'd be happy to learn. Okay, but let's go further. It says that oral evidence must be direct. Now the question is, what is the meaning of direct? That is explained to us in the lines that follow, right? So it says that it should be direct. That is to say, and then it explains as to what direct is. So we do know as to what the meaning of direct is. But there's a question, and that question is, what is the meaning of indirect? You can kind of think of indirect as the opposite of direct, but then it's not as straightforward as that. Let me tell you as to how there is some sort of lack of clarity as to what the meaning of indirect is. So when we talk of evidence, we can talk of one thing as being direct evidence, which we will see in section 60, because section 60 goes on to tell us as to what direct evidence is. And we also know it because we've seen this several times already. What direct basically means is that, let us say, if it was a fact that could be seen, the fact is said by the person who actually saw it. If the fact was something which could be heard, it is brought to the court by the person who actually heard it, and so on, which basically means that the person who senses it is the person who's speaking, and therefore it is direct. Okay, so we kind of know the meaning of direct, and we know that evidence could be direct. And then on the other hand, I just take the opposite of this word, which means that evidence, if it can be direct, it can also be indirect, right? Now here's the thing. Indirect could mean one of two things. It could mean hearsay, which means that the person who's stating the fact is not stating it directly. For example, section 60 requires that if there was an incident and there was someone who saw it, then the person who saw it is the one who should state the fact, right, before the court. So let's say A sees it, then A should come and speak. But let us say A is the person who sees it, he tells it to B, and B comes and states it before the court. Then the person who is stating the fact is not direct, and that's what's hearsay, right? So you can see that it's not direct, and therefore it is indirect. Therefore, hearsay also qualifies as something being indirect. Therefore, that's one meaning of indirect. Indirect can mean hearsay. Indirect can mean that the person who's bringing it to the notice of the court, the person who's coming as a witness, is not the direct witness. That's why it is indirect. However, there is another meaning that I can give to indirect, which means circumstantial. Now, let us say a person A is the person who saw something and he's also the person who speaks it before the court. Okay? But what he saw is not direct. Let me tell you, for example, A is the person who sees and A is the person who speaks. So the person is direct. But let us say that the question is whether C had murdered D. Okay? So the question is whether C had murdered D. So let's say D is now dead. Now the question is, did C murder D? Okay, so let's say this is what you have here. Now, what A saw was that A saw C running away. Okay, so this is what C was seen doing by A. Okay, so this is C. A saw C running away, maybe with a knife in his hand, which is bloodstained. Okay. Has he seen C commit the murder? Or has he seen something indirect? You see, C might be running away, but that doesn't mean that he's killed, right? So when you talk of circumstantial evidence, when you talk about the circumstance, when you talk about a surrounding circumstance, that is also indirect because it is not direct. Had A seen C killing D, that would have been direct. I hope you're able to realize this, that if A had seen the actual murder, that would have been direct. But when A only sees C running away, what he is seeing as far as the murder trial is concerned is indirect. Okay? Which means that indirect in the context of the law of evidence, remember what I'm trying to say? Pay attention. That indirect in the context of the law of evidence could mean either hearsay or circumstantial. That means when we talk of the law of evidence, then indirect could mean either hearsay or it could mean circumstantial. But when we talk in terms of the Indian Evidence Act, and I've told you the difference between the Law of Evidence and the Indian Evidence Act, I will not repeat this for you. Or well, let me repeat it for you. The Law of Evidence is broader than the Indian Evidence Act. So an Indian Evidence Act is basically a part of the Law of Evidence. Okay. So when you talk of the Indian Evidence Act, then indirect basically means only hearsay. And the reason for that is that direct is defined as something that is stated by the person himself, right? And therefore the opposite of that would be hearsay. So when you look at section 60, it tells you as to what the meaning of direct is. So the opposite of section 60 is hearsay, and the opposite of direct is indirect. And therefore, according to section 60 and therefore according to the Indian Evidence Act, the meaning of indirect would be hearsay. But otherwise, when you see the word indirect evidence, it could refer to either hearsay or circumstantial evidence. So, getting back to section 60, oral evidence must be direct. Oral evidence must, in all cases, whatever, be direct. That is to say, so we look at it line by line to see as to what the meaning of direct is. Okay. If it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. Okay. So let us say, for example, now you're before the judge. Okay. There's a witness who wishes to state a fact to the court. Okay. So this person is now before the court wishing to make a certain point to be known to the court. All right. Now, if it refers to a fact which could be seen, it must be the person who says he saw it. If it is a fact which could be heard, it must be the person who says he heard it. Or if it is from perceived by any sense, it should be by the person who actually perceived it in that sense. Let me give you an example to show you as to how this sense matters. Let us say A wishes to state a fact. The fact is that he heard a bomb blast in his office, and the bomb blast, according to him, took place maybe 1.5 kilometers away. Now, is this a fact that could be seen, or is this a fact that could be heard? Is this a fact that could be touched? Could it be tasted? Well, I think it's quite clear this is a fact that could be heard. Okay. So in that sense, he becomes an ear witness, right? This is not a technical term, I'm just saying this just like that. But you must have heard of eyewitness, right? And that's what eyewitness means, that it's a person who has actually seen it, because the fact was such that it could be seen. An eyewitness to a bomb blast, which has happened 1 kilometer away, is not direct evidence, you know. So if a bomb blast has happened 1 kilometer away, the human eye, especially if it's a city, cannot see what's happening 1 kilometer away, and therefore it cannot be an eyewitness who brings it to the notice of the court. However, if instead of the bomb blast, A wishes to talk about the smoke, right, or the smoke cloud, or any such kind of dust which may have emerged because of the bomb blast. So the smoke, maybe that could be a fact that could be seen. Therefore, a person can talk about what he has seen if he's talking about the smoke cloud. If he refers to the sound, it has to be a person who's actually heard it, right? So as you can see, different senses perceive different kinds of facts. Okay, so that's fairly easy to understand. Going ahead, if it refers to an opinion or the grounds of an opinion, then it should be the person who actually holds the opinion. So we've seen that opinions are relevant, right? And if there's a relevant opinion, then it has to be given by the person who actually holds that opinion. For example, section 45 talks about the opinion of an expert. Now, let's say this was a doctor, for example. Okay. Now, you don't want someone else to come and give the opinion of a doctor. So, if the opinion is held by the doctor, it should be the doctor himself who comes and deposes before the court and lets the court know his opinion. You find two provisos after section 60. Pause the video and try to make sense of it by your own self before listening to what I have to say about it. Proviso 1. Provided that the opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by the production of such treatises if the author is dead or cannot be found. Okay. So for example, we just saw finally that, let's say there is something which relates to forensics or medical jurisprudence, for example. Okay. Now you want to get the expert, but the expert is dead, but the expert has written a book. Okay. So now you can get his book to the court, and if the court feels that any other method of getting the person directly is either impossible or not feasible, then you can have the book to state the opinion held by that expert instead of having the person himself. So ordinarily the person should come, like we just saw under section 45. But if the person cannot come, proviso 1 allows for a bit of an exception whereby his book can be brought. Now we come to proviso 2, which is a very important proviso, and it seems to be hidden in this little corner of section 60. Proviso number 2 of section 60 reads as this. And I want you to think for a moment as to what the implication of this proviso is. What is it that is determined by this proviso? Pause the video, take a moment and think about it. Provided also that if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. Okay, let me remind you a couple of points. So we'd seen that we have evidence of two kinds. We have oral and we have documentary. Okay. Documentary evidence means any documents that are brought for the inspection of the court. Go and have a look at section 3. In case that is not very fresh in your memory, make sure you use this opportunity to look at section 3 again, which talks about several definitions, including that of evidence. Okay. So when a document is brought for the inspection of the court, that is documentary evidence. But in this case, it is the inspection of this thing, and this thing is something other than a document. It is not a document. If it were a document, it would have been documentary evidence. So now my question is, this material thing that is brought before the court now, is it oral evidence or is it documentary evidence? So you have this material which is brought before the court for inspection. Is this oral or is it documentary? Pause the video and try to think of it by your own self. Let me give you some things that can help you in answering this question. The first thing that could help you is you can look at section 3, and it tells you as to what a document is, right? So section 3, when you look at the interpretation clause of the Evidence Act, you will see as to what a document is, and you will find a similar definition in section 29 of the IPC as well. You can either look at both of these or any one of these, but you should look at least one of them, and then you can try to answer the question as to whether this material is oral or documentary. When we talk of the definitions of material things, and you've had a look at either section 3 or section 29 of the IPC or both, and then you think of what a material thing other than document is, it's important for us to first find out as to what the difference is. Is there a difference? If you look at what these sections have to say about a document, it is a very wide definition. It does not refer to something as a piece of paper on which something has been written. That is not what a document is. In fact, a document is basically anything that has been written, embossed, or otherwise marked upon any substance, right? So any mark upon any substance by any means is a document, right? So let us say this is a stone. You take a stone and you write something on that with maybe a piece of chalk or with a knife. All of that would be document. So even this is a document. Okay. So what is the difference between a document such as a stone and a material thing that is not a document? Well, what we could say is that perhaps just this stone by itself would be a material thing that is not a document. Also, let us say there's a stone, and with the passage of time, there are some marks on it, right? It's not like the stone does not carry natural marks on it. Those are not documents, right? So when it's a document when there has been something that has been deliberately marked upon it. Otherwise, everything carries marks, right? I mean marks, not M-A-R-X. That's not what I was saying. Okay, so everything carries certain kinds of marks upon it. Okay, and therefore you can't use those marks, those natural marks, as the reason to call it a document. But I hope you get the difference. If there's a stone that's lying by itself, well, it's a thing that is not a document. But if there's a stone with which some marks have been made on it, that becomes a document. Again, if I'm to give you some more pertinent examples of material things so that you understand as to what is happening, let us say there is a gun that is recovered from a certain scene of crime, or you find a knife. Okay, this is what we can perhaps call ballistic evidence. And like I've told you, every type of evidence ultimately has to fall into either oral or documentary, and that's what we're trying to find out right now. Let us say the gun was used or brought before the court to suggest that, see, there's a name A, B, C, D written on that. If you're bringing the gun to the court to show this A, B, C, D, then it is brought to the court as a document. However, when it is brought to the court maybe to indicate the fingerprints, or because it was recovered from that scene of of crime, for example, then it is being brought as a material thing. Okay? Likewise, the knife, which is perhaps just lying there, is brought as a material thing. Further, let us say you find a strand of hair, okay, or you find semen, or you find somebody's DNA, which you can perhaps call forensic evidence, again, which has to be categorized into oral or documentary, which I have still not answered for you. That also is a material thing. Now, what is the difference between, let us say, a strand of hair that you find? Okay, so on the one hand, you can have a strand of hair that you find, and what is the difference between a document? What is the difference when these two are taken to the court? Let us say you give the judge, hey judge, here's a strand of hair, and you say, hey judge, here's a document. What is the difference in these two cases? You see, the difference is that a document speaks for itself, right? But you just place a gun before the court. Hey judge, here's a gun. Look at the gun. Here's a knife. Here's some hair. Here's the DNA. That does not speak for itself, right? So as you can see, when you give a material thing, which is not a document, which is what we're dealing with in the second proviso, when you deal with a material thing which is not a document, then it cannot speak for itself, whereas a document speaks for itself. And therefore, these material things have to be treated as oral evidence. This is also obvious from the fact that you find this in section 60. Right? The proviso is to section 60, and section 60 is in chapter 4, which deals with oral evidence. Therefore, remember that any of these things is always oral evidence. Okay? So I hope that section 60 in its totality is now clear to you. Thank you so much for your patience. Good day.